There's a little delay. I'm just confirming that it's live.
Okay, very good. Good morning. This is Chair French convening the regular business meeting of the Kansas Corporation Commission for Thursday, November 7th. I'm joined by my colleagues, Commissioner Keene and Commissioner Keither. On today's agenda, we have a small consent agenda of 4 items. We have one noticed proposed order, and we have discussion and potential adoption or a public hearing and potential adoption of certain regulations. And at the conclusion of today's meeting, I do anticipate we will enter a short executive session. So with that, we will begin with our consent agenda. Commissioners, you've had the opportunity to review the 4 items on the consent agenda. Let me ask at this time whether you have any questions, starting with Commissioner Keither.
Good morning. No, I don't. Thank you.
And Commissioner Keene.
No questions. I would move approval of the consent agenda.
Second.
Got a motion and a second to approve the consent agenda. Is there any further discussion on that motion? Hearing none, all in favor, please vote aye.
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 Aye. Any opposed, say no. The consent agenda is approved. We will now move to our noticed proposed order. This is in docket number 14 ANGG 119COM, and it is a proposed order on complaint in that docket. Our presenter for this item is Mr. Brian Fadutin. Good morning, Brian.
Good morning, Commissioners. On August 27th, 2013, the Swickies filed a complaint alleging they were overcharged for natural gas under 2 gas service agreements that Anadarko failed to file with the Commission. On January 15th, 2015, the Commission dismissed the Swickies complaint. After 2 trips to the Court of Appeals, the Court of Appeals remanded this matter back to the Commission to, quote, determine whether the Swickies are entitled to a remedy for Anadarko's failure to register the gas service agreements, keeping in mind the prior panel's holding that a claim of illegal rates for failing to register the contracts is equivalent to a claim the rates were unreasonable, unfair, or unjust. However, we stress that a remedy is not required and the discretion on whether to grant a remedy to the Swickies remains with the Commission, end of quote. There, the Court of Appeals found the Swickies claiming illegal rates for the failure to file the GSAs is equivalent to a claim that the rates were unreasonable, unfair, or unjust. Thus, under KSA 66-154A, the Commission is tasked with investigating the complaint and determining what would have been a reasonable and just rate or charge for the services rendered. KSA 66-154B authorizes the Commission to order a refund upon a finding of an unreasonable, unfair, unjust, or unjustly discriminatory or unduly preferential rate or charge. Turning to the 1998 GSA, it's between Anadarko and Swickie Southeast. The Swickie expert suggested that the rate Anadarko charges its affiliates would be reasonable. The 1998 GSA was executed the same day as an Anadarko affiliate contract. Both were for the Panhandle Index plus 50 cents per MMBTU. Thus, under the criteria suggested by the Swicky's own expert, the 1998 GSA is just and reasonable since its rates are the same as an affiliate contract entered into the same day. Since the rates charged under the 1998 GSA are just and reasonable, Swickie SE is not entitled to any relief for Anadarko's failure to register the 1998 GSA. Turning to the 2002 GSA, which is between Swickie SWC and Anadarko, unlike the 1998 GSA, which was easily compared to an affiliate contract, the record does not include any affiliate contracts signed the same day as the 2002 GSA. But as Anadarko explained, it held a limited contract-specific certificate allowing it to furnish natural gas through negotiated contracts. One of the Swicky's experts acknowledged that Anadarko's certificate allows them to charge different rates to members of the same class, so different rates do not necessarily equal unjust rates. In Kansas Gas and Electric Company versus the KCC, the Kansas Supreme Court articulated the general constitutional and legal principles applicable to rate-making decisions by state regulatory agencies. The Kansas Gas case explained that, quote, the leading cases in this area clearly indicate that the goal should be a rate fixed within the zone of reasonableness, end of quote. The zone of reasonableness is a matter for the commission's determination, and the commission has broad discretion to decide what constitutes a just and reasonable rate. When reviewing a contract, at a starting point, staff would look at what other rates were being charged by the entity, and then look to see whether there were other options to obtain service and whether the contract was negotiated by economic equals. Here, the SWCCIs did not always buy gas from Anadarko while the GSAs were in effect. Therefore, the SWCCIs did have other available sources of gas. For example, SWCCI SC entered a contract with Duke Energy Trading within a month of the 2002 GSA. The commission also looks at comparable rates charged to other customers to evaluate the reasonableness of the disputed 2002 GSA. The commission focused its review on contracts entered in close time proximity to 2022. The commission found 3 contracts from 2001 that used the Panhandle Eastern Index and had a delivery charge of the index plus 75 cents, which is 25 cents higher than the 2002 GSA.
Mm-hmm.
Those contracts support a finding that the 2002 GSA rates are within the zone of reasonableness. And since KSA 66154B only authorized a refund upon a finding of an unreasonable, unfair, unjust, or unjustly discriminatory or unduly preferential rate charge, SWCCI SWC is not entitled to any remedy. This order denies the SWCCI's complaint, and this finding is consistent with the Court of Appeals instruction that, quote, the commission is not required to order a remedy, end of quote, and new quote, must exercise its discretionary authority to determine whether the SWCCIs are entitled to remedy, end of quote. With that, I'm available for questions.
All right, thank you, Brian. Before I turn to questions, I'll just announce a reminder that I am recused in this docket, did not participate, won't participate in the discussion and won't participate in the vote. But with that, I will facilitate the vote, and I'll turn to my fellow commissioners to see if you have any questions for Mr. Fedotin, starting first with Commissioner Keither.
I do not, but boy, thank you, Brian. That was a whole lot.
Thank
And
you.
Commissioner Keen.
No questions, but a comment as well. Thank you for the really pretty inclusive yet somewhat succinct overview, Brian, of the really long history
Mhm.
of this particular docket, going back now, wow, a decade. I know in fashioning the ultimate remedy that we're suggesting here, and I know that, in my opinion, through the explanation of how we arrived at this conclusion, I think the order is well drafted, and I commend you for that as well, Brian, and your efforts there.
Thank you.
To me, and I don't mean to have this sound self-serving with respect to the commission, but I genuinely believe that both the approach the commission is taking and the result that is set out today in today's order genuinely fulfills the requirements of the remand. And that was certainly our goal in this undertaking. We've been quite deliberative in thinking through the approaches that we ultimately settled on, and that approach being the zone of reasonableness concept, which I think is going to be fitting in the circumstances. Having said all of that, I would move approval of the order.
Second.
All right, we have a motion and a second to approve the order as described in this docket. Is there any further discussion of that motion? Hearing none, all in favor, please vote aye.
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 Any opposed, say no. And I am recused, so not participating in the vote. But with that, it does sound like the order is approved. Thank you, Brian.
Thank you, commissioners.
Okay, let's see where we are on our agenda. It looks like we have come to our public hearing on adoption of regulations KAR 824-1, 8243B, 8243C, 8243I, and 82430A as permanent regulations. We'll hold this public hearing and then take a roll call vote by the commission. So, and our presenter for this item will be Mr. Hassan Latif. But I will kick us off. So at this point, I am calling to order the public hearing on proposed amendments to the motor carrier safety regulations. Kansas law requires that the commission hold a public hearing before it may adopt regulations. Our staff will provide a brief overview of the proposed regulations, and then the commission will have an opportunity or provide an opportunity for the public to submit either oral or written comments on the proposed regulation. So at this time, we'll move toward entry of appearance and notice. May I have the appearance of counsel, please?
Hassan Latif, appearing on behalf of staff and the public generally.
And does staff have a recommendation on notice of this public hearing?
Yes, I do. Pursuant to the Kansas Rules and Regulations Filing Act, a minimum 60-day public comment period is required before an agency may adopt permanent regulations. And on September 5th, 2024, the commission staff had published in the Kansas Register notice of this public hearing, thereby exceeding the minimum 60-day requirement. Because publication of the notice in the Kansas Register constitutes notice to all parties affected by the regulations, the Rules and Regulations Filing Act does not require agencies to send notices to each party believed to be interested in the proposed regulation. Therefore, staff recommends the commission find that notice was proper and that it has jurisdiction to conduct this hearing at this time and place.
Well, I don't see any other parties on here, but I will, for the record, ask if there are any objections to notice. Seeing none, I will find that notice was proper and the commission has jurisdiction to proceed with the public hearing at this time. And we will then move to the presentation and summary of regulations. And for that, I will turn to Mr. Latif again.
Thank you again. I'm going to share a PowerPoint. Okay, so I think you guys should see that. Good morning again. Okay, the purpose of this hearing is twofold: to provide an overview of the proposed regulations and to receive public comments. That is the entirety of the agenda we have set for today. And I don't believe we have any registrants for this hearing, but if we had, I would note that comments may be limited if necessary to accommodate all participants. The proposed amendments update the certain motor carrier safety regulations to more recent versions of the federal regulations that they adopt, or they reference an updated document. In order to obtain Motor Carrier Safety Assistance Program funding, or MCSAP funding, states are required to adopt certain federal regulations within 3 years of them being promulgated. This allows for motor carriers to travel through different states and encounter substantially the same regulations in each state. We began the process of adopting these specific regulations in June of 2024. And these periodic updates are required, again, to maintain federal grants and funding for safety within our state. I'll discuss the more substantive changes in this batch of regulations individually. I'll just provide a brief summary of each one. All the regulations include some changes, but the majority in all of them, the major change is that it's adopting a new document, a new version of the federal regulation that informed the regulation. So now I'll touch on some of the specific changes made in this round of regulation updates. So for the first one, 8241 is our definitions regulation. This provides definitions for certain terms used in the Kansas motor carrier regulations. And in this case, we have updated the definition of out of service. There's a document that we adopt called the North American Out of Service Criteria, which is published each year, and it defines what an out of service violation is, what the condition that of a vehicle is to cause the out of service violation. And so we're adopting the latest version of that document. 8243B is procedures for transportation workplace drug and alcohol testing programs. And it adopts the 2022 version, which was the latest version when we began this process, available of 49 CFR Part 40. This regulation involves testing procedures by employers, and also, for example, the return to duty status. If there's a drug violation by one of their drivers, the process they would have to go through to return to duty, and how they would have to get approval from a substance abuse professional. So this updates to the latest version of that document. 8243C is testing for controlled substances and alcohol use. And this adopts the 2022 version of 49 CFR 382. This regulation deals with further testing procedures, but it has requirements on what tests an employer has to do, a pre-employment test before they allow drivers to use to drive for them, and also the requirement to check each driver annually in the Federal Drug and Alcohol Clearinghouse. So we have updated to the latest version of that document. 8243I is the parts and accessories necessary for safe operation, and this we're adopting the 2022 version of 49 CFR 393. This regulation adopts technical standards for what qualifies for different parts of the vehicle, of a commercial motor vehicle. For example, there are certain definitions and standards that define what a tail light is, what a windshield wiper is. And so just so there's a baseline for each part of the vehicle, we adopt these technical standards. And finally, 82430A, this is applications for interstate registration. This regulation has to do with the unified carrier registration fees. Those are fees that are paid by motor carriers that travel interstate or leave the state of Kansas. When you leave the state of Kansas, you're required to pay these fees. And then those fees are given back to states in terms of safety funding. The change here is we're adopting the 2025 fee schedule, which goes into effect on January 1st, 2025. And by adopting it now, motor carrier, we're able to enforce that on day one and allow carriers to pay in on the new fee schedule. At this time, I'll just briefly say about public comments. We would normally possibly limit them to accommodate all participants. I talked to PACP this morning, and we had no parties register for this public hearing, and we had no public comments that were received on these regulations. So with that concludes my remarks for these regulations. I would welcome any comments from any party on these regulations. And I can locate my cursor. I will stop my share. Okay, there you go.
All right, thank you, Hassan. Well, we will turn to the public comment portion of this public hearing. As Hassan said, we do not have any registrants. I do not see any members of the public on Zoom, but I am, just for the record, going to pause 1 second to see if perhaps I'm missing someone. If there is someone from the public that has registered that wishes to make a public comment, now is your time to speak up. But that's as long as I'm going to pause. It does not look like we have any public comments. So with that, we will conclude the public hearing for this regulation. Thank you, Hassan Latif, and we will move to the roll call vote from the commissioners. So as I said, we will now move to the commission adoption of these rules by a roll call vote. Mr. Latif, can you give us a little background on this process?
Yes, thank you, Chair. After the public hearing, the next step in the regulation process involves commissioners approving the adoption of these regulations by a roll call vote. By voting to adopt these regulations, the commission would allow staff to send them to the Secretary of State's office for publication. You've already heard the summary of the proposed rules and regulations and are aware of the reason staff's putting them forward to maintain enforcement of motor carrier safety rules in Kansas. Staff seeks the adoption of the permanent versions of KR 8241, 8243B, 8243C, 8243I, and 82430A by a roll call vote. If you have any questions, I am happy to answer them. Thank you.
All right, thank you. Before we move to the roll call vote, let me just ask briefly if the commissioners have any questions of Mr. Latif. Seeing none, we will move to our roll call vote, and I will start with myself. Andrew French, Chair of the Commission, votes yes. Now I will call on Commissioner Dwight Keene. How do you vote?
Yes.
And Commissioner Andy Keither, how do you vote?
Yes.
All right, with that, it looks like we have approval, and Hassan, we will get you the signed certificate of adoption for your processing.
Thank you.
Thank you.
All right, with that, we have concluded our public hearing and we will adjourn the public hearing, but we are still in our business meeting, or we're back to our business meeting at this point. So with that, we have come to the conclusion of all the items noticed on today's business meeting agenda. But at this time, I will move the commission enter into executive session not to exceed 30 minutes to discuss personnel matters of non-elected personnel pursuant to KSA 75-4319B1 to protect the privacy of the individuals involved. And so I guess if it's 30 minutes, the commission, well, I guess we have to take a vote. Do I have a second for my motion?
Second.
All right, we have a motion and a second in our executive session as described. All in favor, please vote aye.
Aye.
Aye. And any opposed, say no. All right, we will enter executive session for 30 minutes. So we will return at 10:51. All right, the commission has returned from executive session where no action was taken. And with that, I believe we have no further business to conduct today, so I would entertain a motion to adjourn the business meeting.
I move that we adjourn.
Second.
Got a motion and a second to adjourn. All in favor, please vote aye.
Aye.
Aye. Any opposed, say no. We are adjourned. Thank you all. Take care.
Thank
Take care.